Hey everybody, Arizona attorney David Ian Bolton here, and in this video I want to talk to you a little bit about some major changes that are coming within the realm of spousal maintenance. That is, if you're watching this video during 2018, which is when it's being filmed. Now, let me explain the old system and then I'll explain to you what the new system is first. So under the old system, it used to be that when you had a spousal maintenance order, also known as alimony in a lot of places, or more colloquially known as alimony, when you had one of these spousal maintenance orders in place, typically what would happen is the person that was paying the spousal maintenance would be getting a tax benefit from that. So that is to say, they would get to deduct that, while meanwhile the person that was receiving the spousal maintenance would have that counted as their income, and so they would be taxed on the receipt of spousal maintenance. That whole system is about to change. So under the Tax Cuts and Jobs Act, which was just enacted, once we hit 2019, from January 1st, 2019 on, this whole system is going to be different. So no longer are you going to get the tax benefits by paying spousal maintenance anymore, nor are you going to get taxed on receiving spousal maintenance, which completely upends the way that divorce negotiations have worked in the past. There's also a separate question about modifications. So if you have a modification of spousal maintenance for an order that was put into place before on or before December 31st, 2018, and then is modified after that, then in that situation, you can still get the tax benefit from the prior system, so long as the new order, when you're modifying it, doesn't say expressly that it's invoking the new rules. So what this basically means is that kind of depends on where you are in this whole equation. Number one, if you're receiving spousal maintenance, in a very general sense, you probably want to have your order signed after this whole law goes into effect. That is to say, 2019 on. On the other hand, if you're the one paying spousal maintenance, presumably you want to get that in by December 31st, 2018. One consideration that you might want to take in, however, is that if you have a situation where you're doing it post from 2019 on, then you're effectively taking away the collective assets that the two of you can benefit from, which can become an argument in a spousal maintenance fight. If you're having to go to the court and get that whole thing litigated, that would be a point that could be brought up. So what I mean by that is, typically, historically, what you've got is you've got a significantly higher income earner that is paying the spousal maintenance to the other party. And so normally they're going to be in a much higher tax bracket. Now, if they're paying spousal maintenance over to the lower income earner and that person's receiving it, historically that person would have taken the same money and been taxed at a lower rate because they're at that lower tax bracket. Now, however, all of that money is getting taxed at the higher tax bracket, which in effect means you're reducing the overall amount of money that the higher income earner has to pay out to the lower income earner. Now, that can become an argument for someone that is having to pay maintenance after this law goes into effect from 2019 on, because now all of a sudden they have less to pay with, in essence, because there's a tax reduction that they're having, or a tax implication for what they're having. So this is a consideration you might want to take in as well. Obviously, this can be a pretty complex issue, so I highly encourage you to speak to an accountant or a family law attorney that's licensed in your state if any of these are issues.